Today's date is June 14th, 2022, and we have for argument State of Ohio versus Randon Griffy. As you can tell, the panel this morning will be Judge Carr, Judge Hensel, and myself. I'll be presiding and keeping track of time. So as you know, each of you will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. I'll keep track of that for you and let you know as you get close to that time. We ask that you keep your voice up because, as you are aware, the arguments are videotaped and played on our YouTube channel for the public. We have read the briefs and we're prepared to proceed. If you are prepared to proceed, just let me know how much time you'd like to reserve and I'll keep track of that for you.
Thank you, Your Honors. Thank you, Mr. Morris. Attorney Eric Hall on behalf of the appellant Brandon Griffy. I'd like 10 minutes of argument and then I'll reserve 5 minutes if I need for any rebuttal, Your Honors. Thank you. The case briefly, the facts are very brief in this case. Back in the summer of 2020, the appellant, Mr. Griffy, was operating a motor vehicle. I believe in this case it was a mini bike. It was involved in an accident, a crash. He sustained injuries and he was taken to the hospital. While at the hospital, the investigating officer sent forms to the hospital to have a blood draw for the purpose of seeing that whether he was under the influence of any alcohol or drugs in that case. In this case, it's important to note, and this is basically the basis of the case, is that there was no warrant obtained for that blood fluid draw, and there was no consent obtained from the appellant, Mr. Griffy.
Counsel, let me interrupt you right there because that was one of my questions. Was the blood draw done at the request of the police officer or was it in the course of his treatment for injuries he sustained in the accident?
Well, I believe that the hospital may have drawn blood for the purposes of treatment, but the officer specifically wanted a blood draw for the purpose of determining whether he was under the influence. And there were forms that were forwarded to the hospital specifically for that purpose, Your Honors. There was a motion to suppress held in this case, and the Honorable Judge McIlvain heard the arguments on this, looked at the briefs. He denied the motion to suppress in this case. At that point, Mr. Griffy pled to the charge. The sentence in this case is stayed pending the outcome of the appeal. There's an important case that the appellant relied on at the motion to suppress was State, and I hope I'm pronouncing this right. I'm going to call it EDS. It's EADS. It's a Ohio First District Court of Appeals case in which that court held that a warrantless search of a person's medical records was in violation of Fourth Amendment rights. However, that court went on to state that the officer's reliance on the statute that RC 2317.02 and 2317.022 to obtain the records was in good faith and did not require the suppression in that case of the unlawfully obtained records. However, other appellate courts have held that that is a violation of the Fourth Amendment. I believe it's State versus Smith, that's Second District. The third and fifth districts have also held that without a warrant, the defendant, a warrant or an exception, the defendant's Fourth Amendment rights are violated. That's State versus Clark and State versus Little, and also State versus Saunders. Now, the 8th district, which is Cuyahoga County, has held that there is no warrant required. Your Honor, I think that if you look at the facts in this case, it doesn't seem like an important case, but I think actually it's a very important case, especially in the context of the atmosphere we're now in this country where the Constitution is being examined, re-examined. Some people are saying that we need a new Constitution or we don't need one. And some of the rights that are enumerated in that Constitution are no longer valid. The Fourth Amendment is is a principal right. And I think in this case, for a state to enact laws or for a police department to have policies or procedures that somehow take away or obviate those rights, it's a clear violation, and it undermines the importance of the U.S. Constitution. So I think even though this case involves a mini bike crash, I think it's a very important case.
Well, counsel, let me just interject as well. I guess when you say the police department adopted this policy and it violates his Fourth Amendment rights, the police developed this policy based on a state statute, though, right?
Oh, absolutely. Oh, no.
Okay.
No, they
So
followed.
and at this point, the state statute has not been declared unconstitutional.
That's correct also, Your Honor. And
So
the
even if
officer-
it's a Fourth Amendment violation, it still comes down to what is the remedy, right?
That's correct, Your Honor. That's correct. The officer, there's no question the officer acted reasonably. He acted in reliance on the statute, and he acted based upon his department's policies and procedures, which were determined at that point he felt were lawful because of the statute. So we're not arguing against that. We're arguing that there's a higher law that supersedes this in this U.S. Constitution, the Fourth Amendment rights granted in that U.S. Constitution. I believe this is an unsettled issue. And really, in this case, if you look at, I can talk, and I don't think Mr. Morris will disagree with me, but judges are contacted at all times and at all hours for warrants on these kind of cases. I mean, they have judges contacted at the early hours of the morning, 3 a.m., where judges will actually even go to the hospital to sign a warrant. So in this case, there really wasn't any exception because Mr. Griffy was hospitalized. He wasn't going anywhere at the time. So it would have been easy to obtain that warrant. However, for purpose of expediency and his reliance on the statute, the officer didn't do that. However, Mr. Griffy's rights, we believe, were violated in this case, and we're asking the court to adopt the holding in EDS and also to further adopt the holding in the other districts that I mentioned, where they found that it was a clear violation of the defendant's Fourth Amendment rights, Your Honor. Thank you.
Any questions, Judge Carr? Further questions? Judge Hensel?
No.
Oh, all right. Obviously, you'll have that full 5 minutes then for rebuttal. We'll hear from Attorney Morris, 15 minutes, sir.
Unmute. Thank you very much. May it please the court. My name is Tom Morris. I'm the law director for the city of Wadsworth, and I represent the state of Ohio. One fact that I did want to clarify, my understanding of this is that the procedure was done in the course of administering medical care. It wasn't us who asked that a blood draw be done. We've done that before, but we didn't do that in this case. It was already done. They had already done the research. They'd already done we followed up afterwards to get the results of it. So this was not something that we were asking to do for that. It was already being done. It was being held by a third party. So we weren't requesting the blood draw to be done in this case.
Okay,
Well,
could you do me a favor, walk us through the difference that makes?
Well, anytime we're taking blood, now we're into Birchfield, now we're into those other cases, which talks about that's a seizure. Once we're taking blood, Fourth Amendment definitely applies, and now we have to seek for, is there exceptions to the warrant requirement for a seizure. When we don't have a seizure, this is just a search of a third party. It's going to come down to a Fourth Amendment analysis. First, is there an expectation of privacy? If you're taking their blood, there absolutely is an expectation of privacy. I would never argue different. But if you are just getting documents from a third party, meaning the hospital, the question is there an expectation of privacy? That's what the 8th District had to look at. They found that there was not, because there was consent or implied consent, and there was no expectation of privacy. Whereas if we were drawing the blood, there certainly would be, in my opinion.
Thank you.
And I'm assuming he did not at any time indicate he was refusing or objecting to the withdrawal of the blood?
I can tell you, when he did go to the hospital, he had said he exercised other rights. He exercised his right to not incriminate himself, not make any more statements. So he in no way said, I am granting the authority to do this. I would suggest that he was kind of the other way around. He was at that point lawyering up and not cooperating at that stage. But this was taken in the normal course of, he was involved in a somewhat serious accident. It was enough to take him to the hospital, and there was normal course, taking blood, and the results were studied therefrom.
And that's what I was just going to ask you. Why would he object to it at that point? Because the point was it was for treatment purposes, correct?
Why do people do what they do? It doesn't make any sense why you would refuse treatment elements of it. At that point, he was, we'd later find out, was intoxicated and was certainly not looking to comply with any orders or requests. I agree with Mr. Hall that this is an interesting case and an important case, just because This is something where multiple jurisdictions are treating differently. And this is the opportunity for the 9th District to do their research, put their opinion forward. But ultimately, I think it's going to be determined by the Ohio Supreme Court as to what's going to happen with multiple jurisdictions treating it differently. There are two questions in here, one more of a micro question, one more of a macro question. The macro question is, does the blood draw procedure set forth in 23CA0028.022, is it constitutional, or is it missing a step? The step would be is, hey, we want the results of the blood draw you did. We want that paper that you already have. But do we need a judge to get the permission to do that to satisfy the warrant requirement? That's the macro question. The micro question is whether it's objectionably reasonable for an officer to rely on a presumed constitutional statute when they ask for it. The language is spelled out in the statute. This is the language you need to do to send it to the hospital for them to send it back. That's the way I taught them to do it for the past 10, 15 years, that you didn't need it because there's a statute right on point. If there is a requirement under the 4th Amendment that was found in the 5th District case, that's going to take the extra step. That's okay, we do that, that's fine. But it will take getting a probable cause hearing in front of a judge to do that. That's not the steps that are outlined by the revised code. And so therefore, the question, was it reasonable, and are we going to make the exclusionary rule apply in this case for Mr. Griffy? I don't believe that would be appropriate because the 9th hasn't spoken on it and the Supreme Court hasn't spoken on it. But the macro question is the interesting one, and that's the one that's probably going up to the Supreme Court, and it takes a review of the 4th Amendment. Where do we start? We start with expectation of privacy. Is there an expectation of privacy for the medical records that relate to alcohol use in an accident? If there is, the 4th's going to apply. If there's not an expectation of privacy, then it would not apply. And then we don't have to try to find an exception to the warrant requirement because it doesn't apply. I would point to the fact that what's confidential and not confidential is set forth in statute. And in the statute, it specifically says that in these types of situations where there is potential crime that can be investigated, we're not going to allow you confidentiality. The hospital has to turn that over to the state. That is by statute. So I would argue that there is no expectation of privacy because the statute specifically says you have no privacy when it comes to that. We do that for different types of things as well. We do it for abuse cases where there's mandatory requirements. We do that for attorney-client privilege. If my client says that they're going to go out and commit a crime, I've got an obligation to drop a dime on them. They do it for clergy. There's an exception. So it's not an absolute, and there's set forth in statute. So I would argue that the statute gives you no indication that you should be expecting this stuff to be private. The hospital is not going to hide evidence of your guilt just for your benefit. It is a third party, and that third party will have an obligation to turn that over. Without an expectation of privacy, there is no 4th Amendment implication, which means the statute's presumption of constitutionality should reign. If you do find that there is an expectation of privacy for those documents, then the next step is there an exception? I don't think there is. And at that point, there would be a warrant that would need to be required to get it.
Counsel, I can certainly understand both the state's and Attorney Hall's desire to have this issue regarding the 4th Amendment privacy right heard and decided by the 9th District, and then for whatever else, for further steps. But in this particular case, the trial court's entry says, I don't have to reach that. I am going to apply the exclusionary rule. And I don't really have any analysis on whether or not the exclusionary rule should apply or not.
That's the good faith exception that's cited in that Eats case as well. I think Judge McElvain also referenced it. It says we look to see if they acted objectively reasonable, and if they do act objectively reasonable, then the good faith exception to the exclusionary rule applies. And if it does apply, then For this case, we are saying, okay, you're wrong. You should have got a warrant, but we're not going to use the exclusionary rule because of the good faith exception, as this is the case law, as my understanding of it. So in that case, that would be something that would not affect this case. The other part would be essentially moot because in this case, it wouldn't do it. But if this court was going to entertain the bigger question, that macro question I talked about, that's why I wanted to talk about how I saw the Fourth Amendment.
Thank you.
Anything
that's
further,
all I got.
Attorney Moore? All right, Judge Carr, any questions?
Oh, no, thank you.
All right. Well, thank you for your argument. Attorney Hall, let me just reset my clock here. You've got five minutes for rebuttal. You may start whenever you'd like.
Thank you, Your Honors. I'm going to be brief. One thing, though, that's concerning to me is that if there's no expectation of privacy in medical records, then where is there an expectation of privacy? Because medical records and medical tests, it's more than just whether somebody's under the influence of alcohol or drugs in an OVI case. I mean, there are all kinds of other things that are contained in some of these medical reports or bodily fluids. I mean, diagnosis of HIV, these are very private and personal things. So to say that there's no expectation of privacy in these things, that's concerning, okay? And just as a Joe citizen, that's concerning to me. The other issue that came up was whether Mr. Griffy had consented, obviously he would consent, or whether he consented to treatment to have his blood drawn at the hospital. I think the court, and probably most people are aware, that you can refuse any type of procedure or treatment while you're at the hospital. So I don't know that it's clear that he consented to having his blood drawn as any course of treatment. You can, if somebody wants to come and draw blood, you can say, fine. You can also say, I don't want my blood drawn. And they will not draw your blood under those circumstances. So I think we're coming down to whether there's an expectation of privacy in these bodily fluids. And I think that, clearly with this, I mean, this goes beyond a case where a warrant's required to get cell phone records. Warrants are required to get bank records and other records. But for somehow, in this case, that somebody's bodily fluids or their medical tests or reports can be obtained without a warrant, but in these other cases that you do need a warrant, I think that that's an issue that needs to be resolved. That the Fourth Amendment, I mean, can't really be selectively applied in cases like this. I think it really has to be across the board and broadly applied. And that's my argument, Your Honors. And I'm going to ask the court for a decision that would grant the suppression of evidence in this case. And of course, after that, there's still the court recognizes, and everybody involved recognizes there's a split, and there's still be a split in the districts. And that's an issue that's at some point will have to be resolved by the highest court in the state, the Ohio Supreme Court. Your Honors, thank you.
All right, thank you, Attorney Hall. Judge Hensel or Judge Carr, any questions before I wrap up here? All right, thank you both for excellent arguments on a very interesting issue. We'll take it under advisement, issue a decision in due course. The clerk will mail a copy of the decision on the day it's released to each of you, and you can also keep an eye out on the Supreme Court of Ohio's website where the opinions are posted.